Donc, je vous remercie
Thank
d'être
you very
présent
much for being
aujourd'hui.
here today.
L'idée aujourd'hui, c'est
The
de comprendre un
idea
peu
is
mieux
to
quel est le
understand a
contenu
bit
de
better
la
what
loi
the content is
et de
about
ce
that
qu'a
law
introduit,
and what
cette, réforme,
this reform
et donc son
means
impact, en fait,
and
sur les
its
personnes,
impact
directement
on
concernées.
people that are
La
affected.
dernière fois,
Last
je me souviens
time
que j'étais intervenue,
I
sur la loi et
spoke
je
about the
disais,
law.
alors c'était le projet de loi,
It
c'était pas
was a
encore tout à
bill
fait la
at that
loi.
time. It was not
Elle n'avait
law.
pas été,
It was
votée
not
et je disais
voted, not
déjà que
enacted
c'était une
yet.
des
But
pires,
I
un
was,
des pires
I
projets de
said
loi qu'on ait
already that it
connus,
was
dans
one
le
of the
droit
worst
français.
bill that we had known
Et
in
je vais
the
essayer de
French
vous expliquer pourquoi.
law
Et
and I will
malheureusement,
tell you why.
la
And
loi, bien
unfortunately,
que le Conseil constitutionnel
the
soit
law
intervenu pour,
has been enacted, even
vérifier la
though the
conformité de certaines
Constitutional
mesures à la
Council
Constitution qui ont été
reviewed
enlevées
that
du
bill
texte
and
avant,
removed
eh bien,
some
on se rend compte que
points.
ce qui reste,
We
c'est
can
quand même
still
extrêmement,
see that there are a
préoccupant
lot
et
of
des mesures vraiment graves
concerning
pour, les
measures
personnes.
and some very serious measures that will
Donc en
affect
fait,
people.
pour nous, cette loi,
So
c'est
this
vraiment un des pires,
law is one of the worst
ces
ever
dernières décennies.
produced in the
Mais il faut
last
savoir
10
qu'en
years.
même
But
temps,
we need
elle
to know that at
s'inscrit
the same
dans la
time, it is
continuité,
part of the
des atteintes
continuity
aux droits des
of
étrangers
all the
des
breaches
précédentes
of
lois. Vous
the
avez
rights of
peut-être entendu
people
parler des lois Pasqua, hein, très
that were
anciennes,
enacted before.
loi
Maybe you've heard
Sarkozy,
about La
loi
Loi
Valls, Cazeneuve,
Pasqua, Loi
Collomb. En
Cazeneuve,
fait, ce sont
Collomb,
les noms
Sarkozy. So you
du
probably
gouvernement, mais
recognize
des ministres
the names or
de
not, but
l'Intérieur
these are
qui
the names
chacun
of
ont voulu
some
laisser une trace,
uh,
poser une marque
ministers that wanted
mettre
to
des mesures
leave some
efficaces.
very strong
Et la
measures
spécificité, donc je dis
and
bien c'est la
important measures. So
continuité
it
des
is just a
dégradations, mais la
continuity of what we have
spécificité de
known for the
celle-ci,
last
c'est
10
qu'elle
years.
touche
But the
à
specificity
tous
of
les
this
chapitres
one is that
du droit
it
des
is
étrangers,
about
donc
all the
l'entrée,
rights
le séjour,
of migrants and
l'éloignement,
foreign
le
people.
droit
We
d'asile,
talk about asylum rights.
la
We talk
rétention.
about
Et donc,
entry in the
tous ces
in the
chapitres, il
country.
y a
We
des
talk about
points
retention. So they are like big
ça va être
changes
un peu
that
compliqué de
will be put into
résumer
place. So
ces
it's going to be
18 mesures.
difficult
Enfin,
to
je ne vais pas
sum up
vous dire toutes les
everything.
mesures, mais
I'm not
simplement
going to
dire
sum up
qu'on va
everything,
discuter très
but
rapidement.
we can discuss a few points
N'oublions
later
pas
on.
aussi un
We
point
need
très
to
important, cette loi,
remember that
comme pas mal
this
de lois en ce moment en France, a
law
été votée en procédure accélérée
has been voted
avec
in
un
an
processus
accelerated
législatif
process. So
auquel on
it's
a
been like
vraiment coupé
it's
court,
speed up process
puisque l'Assemblée
since
nationale
the
a
Assemblée
bloqué en
nationale,
fait
which is the
ce
French
processus
parliament,
en adoptant
has
une motion de
blocked
rejet
this
en
process
septembre
by
2023,
rejecting at the end of
ce qui a eu pour
2023.
conséquence en fait
And
d'avoir un texte qui,
it means that
je
we
pense,
have a
un tout petit peu comme le
text.
système anglais,
It's a
où un
little bit like
système
the
de
British
navette,
system
c'est-à-dire
because
entre deux chambres.
you have two chambers.
Et,
It's a little bit
bien que
similar
ce
here.
processus-là a
So
été
this process
interrompu net,
has been
et c'est
interrupted,
une commission
and it
mixte
is
paritaire avec
a mixed
quelques députés
commission
seulement
just
qui
with a few
représentent les différents groupes
MPs that
au
are
sein du
representing the different
Parlement,
groups within the
qui ont
parliament who
décidé du
have
véritable contenu
decided
de
of
cette
the
loi.
real
Et
content of
donc,
this
je vous
bill.
raconte ça parce que
So
j'ai pris des
why am I
morceaux
telling you that? It's because they've
du travail
taken
du
some
Sénat, du
trunks,
travail de
some
l'Assemblée
bits from the
nationale
work of the Senate,
et
from the
et à l'Assemblée nationale, il n'y a
Assemblée
pas vraiment eu de
nationale,
débat.
and we
À
didn't
la
have a
fois pour
real
des raisons
debate in
procédurales,
the
c'était
parliament. So
quelque chose de
it's
très
been
rapide,
an accelerated process.
et à la fois
And
cet
on top
événement-là,
of
cette
that,
motion de rejet,
this event
ça a pour
with
conséquence que
the
les parlementaires
reject
qui sont
had
censés représenter, voilà,
consequences
c'est au
because
niveau de la démocratie,
MPs
c'est
who
très
were
important,
supposed to
et n'ont pas
represent
pu
democracy
réfléchir,
didn't
n'ont pas
have
pu
the
penser,
opportunity
penser, n'ont pas
to
pu
think, to
travailler
reflect, to
sereinement sur
work
ces textes.
on
Et
those
donc, on a
texts.
parfois des textes
Uh,
qui sont même
so sometimes
quasiment
we've
inapplicables
got some texts that
parce que
are
leur contenu
completely
est soit
inapplicable
contradictoire, soit
because
bizarre relié.
they are
Donc ça, c'est une chose vraiment
inconsistent,
à
they don't
retenir,
make
la
sense.
rapidité avec laquelle
So
ça a
this is
été fait.
something that you need to remember that
La deuxième chose, c'est
the
où est-ce qu'on en est
rapidity with
aujourd'hui.
which this
Donc,
has been passed
cette
and this
loi
has become law.
date du 26 janvier
So
2024
this
et
law
elle a été
was enacted on the
publiée
26th of January
et promulguée le
2024,
28
and it
janvier 2024.
became into
Ça, c'est la
force on the
date de départ de
28th of
cette loi.
January. So that's the beginning, the
Mais il faut
starting
savoir
point
qu'il y
of
a
this law.
donc à peu près plus de
There
55
are
dispositions qui sont
about
restées en
55
procédure constitutionnelle
dispositions,
et il y a des délais
the
d'application
provisions
pour
that
chaque
have been
mesure.
put
C'est
in
un peu
place,
comme dans
and
le
you have
pacte
some delays that are
citoyen.
necessary
Déjà,
for
c'est très
application of those
compliqué,
provisions. So it's something extremely
cette loi.
complicated.
Et en plus, vous
But
avez des
on top
délais
of
qui sont
that, we
très
have
variables.
delays that
Par
are
exemple,
that
certaines
depends,
dispositions entrent en vigueur au
very
28
variable.
janvier,
So it came into force
d'autres
on the
entrent en
28th
vigueur
of January. Some other
entreront en vigueur au
provisions
mois
will
d'août,
come into force in
d'autres au mois de
August,
novembre
others in November,
et d'autres
and
encore jusqu'en
others
2027.
will come into force in
Par ailleurs, vous avez
2027.
des dispositions
there are also provisions that are engraved in the code that are experimental, and they have a date of expiry, which is something that quite unusual. And the Conseil d'État has given an opinion saying that they don't recommend to put in the code of foreigners some measures that are temporary measures, that are interim reliefs. So there are different period, different time, different lifespan, depending on the provisions and the measures. Another aspect that we need to remember is that there will be application decrees on that law. And as long as you don't have any decrees, it doesn't come into force, or it does come into force, but at a date that is mentioned for each provisions. For example, they will say a decree will come into force, or it will come into force in August. So it depends. It's very, very variable. So this is for the law itself. So now I want to come back and give you some background. I'm still in my introduction here. We had a debate in France about the intervention of the Constitutional Council, which is the institution in France that is responsible to check if law is in compliance with Constitution. And this council can decide that if it is not compliant with the Constitution, then it cannot become law. And in France, a lot of associations or people who are working for the civil society had the impression that the Constitutional Council did its job because it removed about 20 articles, about a third of the text. So the Constitutional Council cancelled more than 30 articles. So in the media, in the press, people were very happy. They said, that's amazing. This law is becoming something acceptable, and it's been cleaned by the Constitutional Council. But you need to remember two things. The first thing is that the Constitutional Council examined a very tough version of that law, the tougher version about that law. So it removed what we considered by being the tougher conditions that were introduced by the far right. So being happy because we are removing tough right measures is not the best. The second point is that the Constitutional Council did a cleanup, a partially cleanup of the law, because it's removed provisions that had nothing to do in the law, because they were not in the topic. This is what we call legislative cavalries. It means that they are not linked to the law and they had nothing to do with that. So what does that mean? It means that the Constitutional Council did not declare that it was against the Constitution, and it means that the question remains the same, and all those measures that have been removed, about 30 of them, could just come back in a new text or in a new bill. So they could remain. I'm thinking of different measures. We have something in France which is aide médicale d'État. It is some medical assistance that is granted to people who are not, who don't have paperwork. It means that they can have a package of a minimum care in terms of medical needs. But the council wanted to reintroduce that. But because it had nothing to do in that law, immigration law, they just removed it. And the government is currently working on producing a decree that will weaken this medical support package and reduce the care that people could access when they don't have paperwork to stay in France. The Constitutional Council also removed some measures that were very tough and that were talking about, for example, guarantees for spouse of French nationals, for example. It would toughen the conditions of family reunion, for example, when you when you have paperwork, when you can ask for your family to join you. So all these have been cancelled. 3 of them have been cancelled. One of them was about forced fingerprints during police checks. And this is something that is in the pact anyway. So we will see how the Constitutional Council will manage to cancel this, because they said it was anti-constitutional, but the pact is bringing it back. So I don't know how it will be dealt with in France. So of course, for you, what is interesting is what is in the law. So it is important for me to give you that introduction, because the different measures that have been cancelled can clearly come back at any time. And it has been announced also the end of birthright citizenship in Mayotte and in some other overseas territories. So only people who would be born in Mayotte from French parents could be French, not the others. So it means that that birthright citizenship will be reduced even more. So there are some bills and projects that are planned for Mayotte, which is an overseas territory of France. So what does the law say? So I told you there are still 55 articles, all of which worsen the situation of foreign people. The only exception that you maybe have heard about is the abolition of the detention of minors. It is something very important because in the UK-France and UK-Belgian border, there was the question of detention of minors, and it is something that was very important. According to this law, detention of minors in CRA, which are administrative detention centers, will no longer be possible. So this happened because the European Court of Human Rights condemned France repeatedly, so they had to introduce this new point. Mr. Darmanin, which is the Minister of the Home Office, has already with the Pact Asylum and Migration, he wanted to negotiate the possibility of having the possibility to have recourse to detention of minors. So he was really working for that, and he wanted to make it more general. We need to be careful also, because even if detention of minors is impossible now, the Minister of the Interior has already sent an instruction to the prefects on the 5th of February, explaining that they can still place families in what they call a return preparation scheme. They are not retention centers, but the aim is to is the expulsion in the end of minors, and also to place them under house arrest or detain one of the parents and place the other under house arrest with the children. So I don't know if you realize, but it means that you cannot recourse to detention of minors, but the prefect has the police possibility to say one of the parents will be put in retention and the other parent will be placed under house arrest with the children. So what's the good news in this? Associations were quite happy with the result, saying that detention of minors were suppressed, but you can see that it's not that simple. We can also talk about the short staff sectors resident permit that was in the government's initial bill. It was a possibility to give some paperwork for people who were working in short staff sectors, but this has been blown out of the waters also, because now the conditions for issuing this resident permit for short staff sector have been toughened. The conditions are very strict now. You have to be able to prove that you've had a residence, uninterrupted residence in France for 3 years. So it means that it's for people who are already in France. And you have to be able to prove that you have been working for 12 months in a short staffed occupation, and you have to give your pay slips to prove that. And you say, like, how can people without papers, people who are undocumented can prove that they can work in short staff sectors? So it's very difficult. So you can see that it's very hypocritical. It is not something that will be for people. It will be for a very limited number of people. And it is done only for people who are already in France. And it's just like how to use efficiently immigration and just to fill in the gaps where you have needs in terms of some sectors that are short-staffed. So if I would say like one takeaway about that law is that from the beginning to the end of that text, it is just the prefect that decide what they're going to do. There is a notion of the threat of the public, this notion of threat of the public order. This can be used at any time to change the decision regarding foreign people. I have to give you a summary, and I will give you a summary of some examples that you've got in that law. So because I really want you to understand why it's extremely serious. If I go into the part that is right to residency, you have to remember that the right to residency is going to be even less accessible and more precarious. So the conditions to get residencies is toughened, and people who have been living in France for a long time can be revoked some residency permits. So we will have a more precarious situation for these people. This is possible now with that notion of threat to the public order. So what is that threat to public order? It is not defined. It is like an open notion. So people can decide whenever they want that there is a threat to the public order. I will give you examples of what that threat to public orders are that have been declared by the prefect. So they could remove residence permits or use deportations and expulsions of people for infractions that were done on the road, for example, traffic infractions. If you drive without a license, for example, some people who were also in custody, for example, that where you didn't have any prosecutions after. So the person has been arrested, just sent to the police station, no prosecution, but it is still a threat to public order without any charge. They haven't been charged of anything, but it is considered as a threat to public order. Someone who's praying in the street, for example, this has been considered also as a threat to public order. A young man, for example, was involved in a fight in front of a secondary school, and that fight has been also labeled as threat to the public order. So he was under a procedure of expulsions and the obligation to leave. So these are examples, are like real life examples that were given by lawyers working with our association. So you can see that it's very easy to be labeled as a threat to public order. As to residence permit, we've got a couple of new things here. The measures to access residency is toughened. So you need also to be able to commit to the principle of the Republic. So what does that mean, that notion of commitment to the principle of the Republic? It means that you have a list of different points and principles like freedom of speech. These are very good principles. I'm not questioning that. Liberty, equality, fraternity, brotherhood. So these principles must be respected. And in the case when these people don't want to abide by those principles, won't receive any residence permits. So you can say, yes, it makes sense. If you get into the country, you have to respect the laws of the country and the principles of the country. But if you write that in a contract and you have to respect what does it mean? You can sign or not that contract, but it means that once you've signed that contract, if the prefect considers that those points have not been followed or these principles have not been respected, this can be revoked. So we've noticed that with associations already. There is a law that has been called also enacted, and it was something a bit similar for the associations. They had to respect some principles of the Republic. And we can see for the associations that those associations have been threatened of having the subsidies revoked because the associations did not respect those principles that they have signed for in the contract. They were organizing workshops, for example, or they called for demonstrations, and this was considered as not being part of the principle. So it depends, it's very dependent on interpretation and how you interpret those principles. So it gives a huge power to the prefect and more power to them. Another point about the residency, some people can see their residency revoked also if they have committed something that exposes them to charges. And so it means that if you are condemned or found guilty, you could be revoked. But here, no. It means if you are sued for facts, for example, that could possibly lead to a condemnation, then you could be revoked also. So this is important also when we talk about fake papers, for example, documents, identities. These can be considered as some fake documents. And this could go into that category, which means that the prefect could decide to remove or revoke your residence permit. Another point also is the temporary residence permit, which are two types of permits that you can have in France, can be refused to a person who did not execute an OQTF. OQTF is obligation to leave French territory. So it means if you had received that obligation to leave French territory, if you did not execute that, then later on you can have your residence permit to be refused. And the prefects are really using this not to give residence permits. So when we give some support to people, you have to make sure that you need to tell them if they're asking for residency. The idea is to make sure that you check all their backgrounds. Have you been sent to custody? Did you have a speed limit offense? Did you have an OQTF, which is an obligation to leave French territory in the past? Because all these will become something that will be used by the prefect to have their residency removed.
So for asylum, two ways. First, there is an institutional reform that everything is kind of reorganized, gathering all the services from the prefecture and the different foreign offices. So we kind of gather in one single point all the people in charge of of providing a residency permits, but also reviewing the asylum claim. So all these services are gathered in kind of these centers. So you can question how the prefecture will not kind of influence or have an opinion on the asylum claim. So continuing, in case of appeal, still for asylum seekers, this territorial chamber or court will actually move, and these will be also centralized in Lyon, Bordeaux. So this appeal will actually be available in some chambers. So some people like it, some say they don't like it. Some say that it will then be easier because it will be decentralized, but this decentralization may have an impact on also the decisions and the consistency. Still on asylum seeking process. So if basically the person and the asylum seeker was living in an accommodation, if this person decides to leave here at the center or the accommodation center or goes anywhere else without a justification, well, then there is an option for the administration to literally drop the whole asylum seeker process. So this makes things extremely complicated. And if there is a refusal of material reception conditions, those will become automatic in some situations. So I'm not going to go through the list, but there's a whole list of situations in which asylum seekers will not have the possibility to receive any material support upon arrival. And there is also still for the asylum seeker process, if a request or a claim was closed after the appeal, and if the answer is negative, automatically this person has to be removed from the territory. So that was on asylum seeking. The third chapter, I included here evictions. And then after this chapter, I'll just conclude on the first examples of the implementation of this law or this act. Okay, I have 10 minutes, so I'll manage that in 10 minutes. So the third chapter, so this is still about detention. So in France, we had a system that was called a protection against here the possibility of being removed. So people, for example, living in France since they were 13 or living for more than 10 years in France. These could be also partners of French citizens. If you're a foreigner but sick, all those are what they call protected categories. So it doesn't mean that they were really protected, but just the law basically could not force them to leave the territory, could not evict these categories. Now, all these protections have been literally annulled. So they can be evicted if they went to court and they were found guilty of an offense. Here that can mean basically that they can go with sentences of 3 years or more. So if they are convicted of an offense punishable by a sentence of less than 3 years, then it is not applicable. But for these people protected against any eviction and deportation, then they will be able to be deported in that case. if there is an offense punishable by sentences of 3 years or more. So if you think about it, maybe you're going to tell me, well, they did something wrong, so isn't that normal that they can be deported? I understand the logic, but in France, we have to be careful because there's been 30 years that we criminalized foreigners, to consider them as criminals, to arrest them easily. So they kind of become a scapegoat of the migration policies. So when you see people being arrested and convicted, those are more and more frequent. So as I was saying, these protected categories are not protected anymore. They can be deported now. There is also here two measures reinforcing here the fact that if you've been here deported from France, you cannot return to France for 5 years. So you will need to stay away from France for 5 years if you've been deported. And now, as you can see, that this can also be applied here to these protected categories, such as, for example, partners of French citizens or foreigners with French children. So here, it's a long time, 5 years. In the past, it used to be 2 or 3 years. And for the detention, if there is a house arrest, this could be a renewable here, so renewable twice instead of once. And it can also be a longer term house arrest. So I'm trying to keep it simple. Let me just verify something. So if you have someone that is under an eviction order, can be placed under house arrest if there is a threat to public order. So as I can say nowadays, they can use here the public threat very easily, so they will be able, or at least placed under house arrest for a very long time. Same thing for asylum seekers, unless those that were in the Dublin project, so nowadays they can also be placed under detention. So I believe that it's already the case in some countries to kind of detain here asylum seekers. I know it's the case in Germany, but in France it was not a possibility unless, of course, he was under the Dublin regime. So this is a major change. Now these people will and can be detained. So to conclude, if you are interested, if you want to know more about some aspects, I will also share some material in the chat to understand better when these provisions will be enforced. We also have other additional texts that were drafted to enable, of course, the prefectures to enforce this act. For now, it's quite difficult to measure the concrete impact of this new act, but the public threat order already existed. So it's not the first time that this is used for deportation or detention of foreigners. This was already in practice done by prefectures. But now it's just going to be easier. The prefect will be able to very easily withdraw residency permits or refuse residency permits for, you know, under this excuse of a threat to public order. So this is just a continuation of what we've been experiencing for years. We also see that now to go to prefectures, it's very difficult to get an appointment with a prefecture to get a residency card, and more we actually see that sometimes no appointment is actually given because they are under a threat of a detention or eviction. So literally, there is no appointment. So immediately they said that they are told, I'm sorry, we're not reviewing your file, we're not giving you an appointment for a residency card. The answer is no. So in practice with our lawyers, we can see that the practices are very different depending on where you are on the territory. And I don't know what was going to happen at the border with England, but what we are going to notice, I believe, is a lot of more of violence and sanctions. I think this is going to strengthen this feeling of impunity for law enforcement. And of course, I'll be very interested to discuss and maybe hear about the impact of this new law in practice at the border. Thank you very much for your attention. I know it's very technical. I know it's complex. Systems are different, and I just try to keep it simple as much as possible. Thank you.
Merci beaucoup, Anna. Merci pour cette.
Thank you, Anna. Thank you for this presentation. Thank you for preparing everything. So if you have questions or comments, you can raise your hand if you want to take the floor, or you can also text in the chat in English or in French as you wish. The floor is yours. And waiting for your questions, actually, I have two questions. So based on the feedback from the migration lawyers and the extensive use of these threat to public order grounds, so is that kind of just accepted? Or my question is, can lawyers act upon this? And then when it comes to the detention of minors, you mentioned so that there was a law on Mayotte, on this overseas island, because I believe that the majority of children here that are in detention are in the overseas territories, including Mayotte. So I don't know if you've got more information on the situation on the ground there.
Très bonne question, Nawal. Merci beaucoup de les
Thank you for both questions, Nawal.
Donc, sur Mayotte,
for Mayotte, let me start with your second question. You're right. The vast majority of children being detained, and actually I had the figures here, but I can't find them now, but the vast majority of children in detention in France are detained in Mayotte. So it's more than several thousand of children. And in France, it's more around 500 or 600 per year. We're talking, these numbers are per year. Another detail, I told you, of course, that some of these provisions will be implemented or enforced later. And of course, this provision will only be enforced in 2027 in Mayotte. So that's definitely not for now. What is the problem for us is that children being detained will continue to be detained. and we'll have thousands of children that will be detained. And when we say 2027, that's a long time away. So we're not even sure it will be enforced. And in Mayotte and other overseas territories, we know that there is a kind of an exceptional regime in an exceptional regime and a lot of specificities. And that's a very good example here. Your first question on the work that we do with immigration lawyers, that's a really good question. Very often the lawyers can help. And yes, they can very often get these charges for threat to public order dropped. So if it's the first time, for example, someone is actually accused of a threat to public order, lawyers manage very often to get these charges dropped. The problem, though, is that you need access to a judge. You need to be able to file your claim within the deadlines. But because this time the prefect will be able to act a lot faster, and I'm sure that, there's going to be a lot of appeal. So because it's going to be more arbitrary, as the prefect will have more room for maneuver, well, that means basically more decisions taken. And because these decisions are taken in an arbitrary way, that means more appeals. So that's going to be difficult. So I didn't talk as well about, digitalization. So we don't really go to the prefecture anymore to get a residency permit. Well, nowadays, once the file has been submitted, the prefect issued a decision. And if this is a no, you are a threat to public order, we will not here grant you a residency card. Well, all this will be sent then to the legal system. And obviously, we just here going to end up in a bottleneck with the courts and the tribunals, and that's going to be extremely difficult, and that's really not going to be helpful. So I hope I answered to both your questions, Nawal. Yes, you did. Thank you. Now it's your turn.
I also had a question if there's not someone else. Thank you so much, Anna. It was really, really comprehensive and helpful, and really concerning to hear about the bill and so many of the things that we've seen in the UK over the last several years. Sounds like it's now kind of happening in France as well. So, yeah, I guess one thing I was wondering was whether I've got Rwanda and everything happening in the UK in my mind, and whether you see this bill as kind of paving the way for something similar, and if you think that that could come out of this legislation.
Oui, alors par rapport au Rwanda.
So with your example with Rwanda, so specifically, France actually did not issue an opinion on this bill. However, France is a big champion of externalization, and France has a lot of bilateral agreements with other states to very easily send people back and deport people back to some countries. France, some years back, actually tried to send some admin workers to some other countries so they can kind of process asylum claims as early as possible before people arrive on the French territory. So I will say that as of now, and I can be wrong, and maybe other people have a different opinion, but I believe that as such, I don't think that France is moving towards a Rwanda-style decision. I also don't think that France is hostile or against these type of externalization or subcontracting contracts. And I just believe that France is waiting for the right time to do the same as the UK. So I hope I answered to your question. But I really sincerely believe that as the situation is evolving, I do believe that, yes, France will follow. I think everybody's looking at the outcome. And I'm very sensitive to what you say when you talked about this hostile environment in the UK, what is been created in the UK for years. And I believe that that's what we're also seeing in France. It's exactly the same. I believe that France is also creating this kind of a hostile and fear climate. And the proof is in the pudding, in a sense, because if you look at this text, it is about deporting, criminal migrants. So, it's just like it's written, and when you quote about delinquency or public threat, and also when it comes about fraud, I think it's repeated and repeated again in the text. So yes, I completely understand your question, and I do believe that France will follow. But as of now, I haven't heard of any type of negotiation similar to the Rwanda agreement that the UK signed.
Merci Anna, je vois qu'il y a des
Thank you. Anna, I see Lauren as well wrote down in the chat that yes, there's a lot of bilateral here agreements and agreements with Tunisia, for example, to prevent illegal migration. So do not hesitate, Lauren, if you also want to discuss this. But that's true. That's right. There's a lot of bilateral agreements between France and other countries. I see a question from Anya. Could France use the overseas territories as a way to externalize the borders and to increase here deportation without signing a Rwanda-style agreement?
Merci. Alors, essayons, ne leur donnons pas
So let's not give them the idea to use the kind of faraway islands to evict people, because yes, in these overseas territories, the practices are much worse than in metropolitan France. So I'd rather talk about eviction. So yes, it's very often done a lot faster, targeting some people, whereas it's totally forbidden. I'm just generalizing somehow, but if I take the example of Mayotte, this is an extremely hostile environment. So I think it's already somehow the case. So it's not a border externalization, but yes, we are doing it a lot more on these territories to avoid people reaching the metropolitan area. And I believe that the EU is doing the same. There's been a lot of bilateral agreements signed between the EU and third countries to promote and facilitate these evictions, like with Tunisia, but a lot of other countries. And if you look at maps, that's actually fascinating. When you look at all the different agreements between the countries, and it's more than a spider web, it goes always. And I think it's fascinating because after this pact, this is not a pact, it's not an agreement, but you have 15 states who basically literally said that they wanted an agreement, like a Rwanda style, and they wanted their own externalization agreement. So here there's this, for example, in Italy, Cyprus. So I'm not sure why Cyprus, but a lot of countries in the EU which would like to have the same Rwanda type contract. So I think it's good to look at these kind of announcements, because I believe that these countries, I guess, are not really happy with the pact and this compact, and they probably want to sign a lot of different agreements to externalize the demand and avoid people arriving on their territories. So I think we'll need to look at that. Let me just come back on detail, but there is this option to externalize for border control and asylum processing. But for an eviction in France, and I believe it's the same everywhere, you also need the agreement of the destination state. And in France was a big champion, because as some consulates, as for example, Senegal and Morocco, were not actually given the permission for these evictions, they implemented the European year agreements to overcome this barrier to facilitate eviction. And this same act, there is a provision saying that all the countries that will not cooperating with France will not be granted visas for their citizens. And I think this already existed. It's not new, but I think the intentions are extremely clear. And they want like the third countries to cooperate. So I know I'm adding a lot of more information, but yeah, I think it's relevant.
Pas de souci. Il y a une question.
There is another question here from Michael in chat. If there is time, would you say a few words about what you think of the most likely immediate steps that the French government might take to reintroduce some measures that were not allowed to go into force? So I think you've mentioned a few provisions that could come back, but would you also summarize some of the risks for the coming years?
Oui, alors c'est vrai que c'est un vaste chantier, enfin, c'est une vaste question.
It is a real question.
Parce que donc en effet, j'en ai un petit peu parlé.
Indeed, I talked about that with the aide médicale d'État, which is the medical assistance offered to people who don't have papers, who could access medical care. But this is questioned every year by the government. Every year they're trying to question that and try to remove that. It's something we're talking about public health. We consider that people coming to France, even if they are undocumented, they have to be they have to get medical assistance and medical care. I'm not talking about some very heavy medical needs. I'm just talking about basic things. Go to the doctors, go to the GP, have access to emergency services. So it is very unlikely that it is revoked. So we're watching that. We are looking at this to make sure that we can avoid this from being revoked. So I talked about Mayotte also, but I think that the conditions of a family reunion, which gives the possibility to the people to gather, like family gathering, family member reunions, this has tougher conditions now, because they want to prevent, the government wants to prevent families to meet people who are in France already, people who are working in France. And how do they toughen those conditions? Well, they they increase the level of French proficiency. They are asking for more larger accommodations. So they give, they manage to find other possibilities to toughen these conditions. So this is going to come back, I believe. Conditions for students also, this is coming back all the time. Young people who are students, and they have their resident permits are not they are not counted for the number of years that should be taken into account later on. So I think for students, it's going to be tougher. Minors also. I think minors will be the object of further attacks. So minors or young adults. This law created a record, a file where fingerprints are recorded for minors when they are delinquents. So once again, we're talking about crime and delinquency. So there's a file that has been created, and I think minors will definitely the priority target for the governments. When I say minors, I'm talking about those who are 15, 16, 17. I'm talking about those who will be adults soon and who will probably very likely ask for resident permits. It's very difficult to talk about that because, in France, you've got the European elections, but there will be also the presidential elections coming soon. And that, I think, will change the game also. So my answer to your question is, I think it's in the next 2 years. So Michael, for after those 2 years, we don't know. Maybe it's going to be even worse.
Merci Anna pour cette réponse.
Thank you, Anna, for this very good answer. I just want to add a comment because I can see that there is no more questions. So I will take this opportunity to make a comment. We still have 10 minutes. So about the fact that they are always questioning this medical help, I want to draw a parallel with what you described earlier about the hostile environment. It's very symbolic. It's like the tree that is hiding the forest, as we say. It's something that is brought back to the table all the time. First time, people, oh, that's an outcry. We cannot revoke that. And then it's coming back and back again. So people get used to that. So it anchors the idea that we are questioning the fact that these people can access healthcare without having documents. There was a strong mobilization against that measure during that bill in France, but also it concentrated, it was something that everyone had an opinion on and everybody agreed on that. So we had the impression that we avoid the worst case scenario because it didn't go through. So even if it didn't go through, I think it's a good indicator to see that it's always coming back to the table. It's always something that is being questioned. So there is a clear deterioration of the situation, and little by little, I think it's the public opinion is getting to that idea. So it is a legitimate debate now to ask whether people can access healthcare or not, and it could be considered as something logical for some people.
Nawal, si je puis réagir, je te remercie.
Nawal, thank you very much to talk about that, because in Gisti, during all that time when we had discussions on that bill, it is something that we discussed many, many times. We've got the strategy of drawing your attention to something else while you are doing something else behind. So it was that question to access social subsidies, social benefits, and how those people could access those benefits. And I think it concentrated a lot the mobilization, and people were just thinking about that. And because it has been revoked and removed from the law, people said, oh, great, amazing, this has been removed, that's victory. But no, because a lot of things were adopted. So it was more sneaky, if I may say. So the people who are affected by that law were not the people who were targeted by the Home Office, because the Home Office said that I want to deport people who are accused of terrorism. But no, this law now will affect people who've been staying in France for years and years. It will affect families. It will affect people who's been here for like 3, 4, 6 years now. And because, for example, they don't have a good a level of French that is not good enough, for example, well, they won't have their paperwork. They will stay in a very precarious situation. So it will give more precarity to these people. And the last thing that I want to say, I told you that our lawyers have to ask people if they did something wrong in the past that could be held against them. And I think this is very, it's terrible to say that, because you have to make sure that the person didn't commit any crime, they didn't have an obligation that leave France territory that was not completed. Because if you end up at the desk and the lawyer is just learning at the same time, like, oh my God, I cannot give you residence permits because you don't remember you had a speed limit in 2012, for example, or in 2020. You had a speeding ticket. I'm sorry, I cannot grant you residence permits. And that the lawyer and the person, the applicant, is learning about that at the moment they are applying. So I think it's terrible now to ask people to check within their past to make sure they have a super clean background, because otherwise it could be clearly a threat for their application. And I think that this is really the point that is really like it's a very bad aspect of what is being done today, I think.
Merci Anna pour ces éléments
Thank you, Anna. Thanks for that. And I think, yes, it interferes in the relationship of the people applying and also with their lawyers. I think it's very important to remember all that.
Évidemment, les Français sont très forts pour casser l'ambiance.
French, French people are very good at talking about things that are very negative, but I think it's very important for me, within the cross-border forum, to see the mobilization that we see in the UK, but in Belgium, but also in the UK. For nous, it's extremely inspiring what you're doing over there. We need to see the mobilization, see what you're doing. I think we shouldn't give up. Even if we have the law that we have today, we need to keep in mind that another law can remove what has been done. So we have a duty. We have a duty to inform people, to support them as much as we can, to work with them. But I know that in France, there are a lot of places where there are like local committees of support that are being created. And I think we need to keep that in mind, that there is a lot of resistance. And the tougher the laws, the more places of mobilization. So I think it's important to keep an eye on all the solidarity movements. It's very inspiring for us. So I just wanted to give a positive note for the end of that meeting.